Good morning, folks.
Good morning.
Can everybody hear me?
Yes, good
Morning.
Good morning. Okay. Mr. Moya, let me know when we are ready to go live.
Mr. Chavez, we are live and you may proceed.
Wonderful. Thank you. Okay. Good morning, everybody. It looks like we are all here. My name is Stephen Chavez. I am the land use hearing officer for the city of Albuquerque. I'm sorry, I was thinking about another hat I was wearing moments ago. And today's date is March 31st, 2022. This is an appeal from the zoning hearing examiner, the ZHE, and it is appeal number 22-4, it looks like. And I've read the entire record. I would like the appellant to make his entry of appearance. Who is the appellant for today?
Mr. Chavez, my name is Kim Murphy. I'm the representative for the appellants, Kevin Murphy and Kelly Judkins Cooper.
And you are not an attorney, correct? You're a real estate broker.
Well, I'm a real estate professional. I have a master's in urban and regional planning.
You are not an attorney, correct?
Not an attorney.
Okay, good. I will have to swear you in. Is Mr. Rayner or Miss Rayner here?
Yes, this is Kylie Renner.
Hi, I'm sorry, I mispronounced your name. Kylie
It's right,
Renner.
and this is Zephyr Renner. We're both here.
Good morning, folks. Okay, so I'm going to swear Mr. Murphy in, and then I'm going to swear both of you in. Actually, let's do it all at the same time. So all three of you raise your right hands, please. Do all three of you affirm to tell the truth, only the truth under penalty of perjury under New Mexico law?
I do.
Mr. and Ms. Renner, I didn't hear you. I'm sorry.
Yes.
Yes.
Yes, good. Okay, Mr. Murphy, go right ahead. I have read the entire record. Oh, before you begin, let me deal with some prerequisite preliminary matters. I did receive a supplemental argument from you. Thank you for that. I will include that in the record to the city council. Ms. Renner, I did receive your, apparently you submitted it looks like a permit for what is it, a rental permit? Got that into the record? No problems with those. Mr. Murphy, go ahead.
All right, Mr. Chavez. I beg your indulgence as well as the other participants, given the depth and breadth of our argument. I have prepared a written presentation, which I'd like to read. It'll take about 20 minutes.
I'm not going to give you 20 minutes. If you could go a little faster than that, I'd appreciate it.
How much time will I be allowed?
I'll give you about 15 minutes for this one, okay?
All right, very good. Good morning. I'm Kim Murphy, representing the appellants in this case, Kevin Murphy and Kelly Judkins Cooper. This case is an appeal of conditional use approval of an accessory dwelling unit without kitchen located at 2702 Morrow Northeast. Our argument is based on one, a technical analysis of the IDO that shows that the stated purpose of the owner for the accessory building conflicts with the zoning approval. Two, new information obtained from the planning department not presented to the ZHE, which shows that the owner's actual purpose for the expansion of the short-term rental use on the property. And three, an analysis of the business use of the property, which exceeds the definition of home occupation and therefore is a violation of the IDO. The appellants have provided written argument dated March 15, 2022, and supplemental information dated March 28, 2022, pointing out several procedural concerns with this case as well. We have also asked that new evidence be accepted into the record, both of which were the subject of IPA requests based on appellant Murphy.
I'm not going to allow that into the record. I'm not going to let you use the IPRA process for this process. They're two separate processes. If you have the records now, you can submit those into the records now. If you don't have them, I'm not going to allow them. Okay? It's inappropriate to use IPRA to use this hearing to get IPRA documents in through the back door. I'm not going to do that for you. Go ahead, sir.
This information is
I'm not going
this
to
is-
argue with you, Mr. Murphy. I'm not going to argue with you. If you don't have the documents here today, I'm not going to allow you to use this hearing as a backdoor, basically placing the obligation on me to obtain your IPRA records. That's inappropriate. I'm not going to allow it. So let's just move on.
Can I explain?
No, I'm not going to
No.
allow you to explain. It's not relevant. Okay?
Sir, please.
Look, Mr. Murphy, I am not going to argue with you. Your time is running.
This information is in our written argument. So has that information been accepted?
I've accepted the entire record that's in the record now. What I'm not going to do is allow you to use this hearing to essentially obligate me to obtain your IPRA records.
I'm not asking you to do this. This information is identified in our written argument as new information. If you say our written argument has been accepted, then it's been accepted.
Whatever's in the record is in the record. Okay.
The renters have referred to here as the owner applicant have declared their intended use of the requested accessory building as dedicated space for business activities. The planning department has processed the request as an accessory dwelling unit without a kitchen. From the outset, we viewed this discrepancy as puzzling, one that perhaps should have been a red flag to the planning department and ZHE. We can only conclude that the planning department assumed that a home office, which is a permitted accessory use for a primary dwelling and is defined in the IDO as a home occupation, it is also a permitted use for an accessory dwelling. It turns out that this assumption is incorrect. Home occupations are not allowed accessory use within the IDO. Our argument is supported by a detailed analysis of accessory uses under the IDO. It demonstrates that accessory dwellings have a unique defined relationship to the primary dwelling, typically to provide living and sleeping space for independent or semi-independent family members in a separate structure. But in this case, the owners don't intend to use the accessory dwelling for residential purposes. The stated purpose is for a home office. As new evidence not available to the ZHE demonstrates, their actual purpose is much different. That is the expansion of their short-term rental business, called herein as STR. Our analysis shows that STRs are also not allowed in accessory dwellings. Only certain uses that are accessory to the primary dwelling are permitted in a separate accessory building. The accessory dwelling is one such use, but the rational nexus between the accessory dwelling and the primary dwelling is residential. Validating accessory uses that are customarily associated within the primary dwelling as being allowable within a separate accessory dwelling not only defies logic, but by extension opens the door for a wide variety of accessory uses to be considered as well, such as family care, daycare, second kitchen, short-term rentals, thus turning the IDO on its head. Think about it for a minute. If an accessory dwelling without a kitchen can be used for business purposes, why not daycare or family care? These are accessory uses that are allowed in the primary dwelling, largely because of the support spaces provided there as an integral unit, such as the kitchen, bathrooms, living rooms, etc. This is the central theme of our case, namely that the exclusive residential relationship between accessory dwellings and primary dwellings. Another second theme is the owner applicant's stated purpose versus the actual purpose for the proposed accessory building. We noted a discrepancy that has come to light since the hearing. This relates to the existence of a building permit application, including construction drawings for an accessory building submitted by the owner applicant approximately 1 month before the conditional use application. It would appear that the Building Safety Division was holding the permit until the conditional use had been approved, because the building permit was finally stamped approved just 2 days after the ZHE decision.
What's wrong with that? Let me interrupt you, and I'll give you appropriate time with your argument. My question is, what is wrong with one division of the planning department holding on to construction plans until another division, the zoning hearing examiner, reviews and either approves or denies the construction plans for the conditional use?
Our argument is that the construction drawings that were submitted for the permit show a use that is not consistent with the requested zoning that was before the ZHE.
So that doesn't answer my question because it's not what you said earlier. Do you have a copy of the construction plans for the record? Because I don't have I just have a drawing of the proposed dwelling or building structure.
You have a floor plan that was part of the construction drawings that was submitted with our written argument, and that floor plan shows spaces for a large commercial. We consider a commercial type laundry kitchen facility, and that includes two washer dryer units, a refrigerator, a dishwasher, utility sink.
Where is that in the record? Where is that in the record? Point to give me the number in the record where that's at. And now I've seen the drawings. I didn't see the detail of those drawings.
It's in our written argument.
So you don't have copies of the construction drawings that you've just described?
Yes, it is in the written argument. The floor plan that illustrates what I just showed is in the written argument.
Where in the record? The record's numbered. It's Bates stamp. Can you tell me where it is in the record? The reason why I ask is because I don't have it.
You don't have a written argument?
I have your written argument, but I don't have construction plans or any drawings with your written argument.
It was attached as Exhibit A to our written argument.
The supplemental argument or the argument that you included in the record when you appealed?
No, you must not have the complete information because a written argument was prepared dated March 15.
Okay, March 15. Let me look at my record a little closer because what I have in the record is on page 09009 of the Bates stamp record is your application for the appeal. And then on page 10 and page 11, it looks like through page 13, from 10 to 13 is your written argument. I have an Exhibit A, which is an authorization letter on page 14. On page 15, well, let me finish. On page 15, okay. I have a document with your letterhead dated January 14th, basically exhibiting the approval by your clients for the appeal. Exhibit B identifies a list of things, but I don't have anything other than that. And now I do have a request for special exception, and then it starts with the record again. So what is missing from this record?
There's probably a 15-page written argument that's dated March 15 that you were copied with, should be in your possession. What you just referred to that's part of the package that went to City Council is our justification for the appeal itself, not our entire written argument.
Okay, Mr. Murphy, you don't describe these to me as if I don't know what I'm doing, because I've been doing this a very long time. I'm telling you what's in the record, okay? So apparently there's something missing from the record. And you said it's dated March 15th?
March 15.
And how many pages is it?
Oh, it's approximately 15 pages.
Okay. And that includes the construction drawings that you've been, the detail of the construction drawings that you've been describing, correct?
Yes, sir.
Okay, with your argument, I will find out why we don't have that in the record. But what I'd like you to do, in case there was an error that was made by the planning department, can you submit that into the record? Can you shoot an email to Crystal Ortega, the city council clerk, that would have those documents?
Absolutely.
Please do that today if you can.
I
I
will.
don't have, wait, let me finish. I don't have that in the record now. So, I mean, feel free to describe that with particular detail. I'll give you more time for that. Send your email to Crystal Ortega. Don't make an argument. Just include that into the record and make sure you copy the party opponents, the renters. Okay?
Yes, sir. I will resend the email that I sent to her.
Okay. Now I do have in the record it looks like it's an email from you dated March 28th, and it's a 2-page supplemental argument, I suppose. It says appellant supplemental information dated March 28th, 2022, and it's basically just a bunch of questions you have for staff. I don't see anything attached to that. Was there anything supposed to be attached to that?
No, that's the sum total of our supplemental information, 2 pages.
Okay, so what you should also do, just to so we can stay above board and be appropriate, send Ms. Ortega a copy of your email. Apparently, you sent it via email to the city council, and send her a copy of that as well, so that I can include that into the record. So it sounds like an error was made, and we can correct that right away. Okay, we will include those documents in the record.
Okay, very good. Would it be all right for me to proceed?
Yes, sir.
I was talking about the discrepancy that we see between the stated purpose of the owner applicant and the actual purpose, and the discrepancy that has come to light since the ZHE hearing. This discrepancy relates to the existence of a building permit application, including the construction drawings for an accessory building submitted by the owner applicant approximately 1 month before the conditional use application. It would appear that the Building Safety Division was holding the permit until the conditional use had been approved, because the building permit was finally stamped, quote, approved, just 2 days after the ZHE decision. Unfortunately, neither the planning department nor the owner applicant disclosed the existence of the building permit, and more importantly, the actual purpose for the accessory building as indicated in the construction drawings. We believe that the actual purpose is an expansion of the short-term rental use of the property, not home occupation use, and not creative project use, as was testified in the ZHE hearing.
What evidence supports that allegation? And I know you've made the argument before the ZHE, and I thought it was responded to, maybe not clearly, but it was responded to by Miss Renner, I believe it was. I might be wrong. It might have been Mr. Renner, but one of the two responded in the ZHE hearing and essentially said that, well, it's going to be used for our office and for closet space, essentially. What information do you have that you can present to me that they were not being truthful?
Well, it's and I will jump to it. It deals with what the subject of the building permit, which were construction drawings that showed spaces that were different from what they were describing their intended purpose to be. And those drawings showed a large, what we call commercial type laundry and kitchen space that had two stackable washer dryer units, a refrigerator, utility sink, and dishwasher. And we would just ask, why is an additional laundry facility separate from the primary residence needed? And why 2 stackable washer dryer units? Why are they needed? And why is a refrigerator and dishwasher needed? And we conclude that particular space is there to serve their short-term rental business on the property, so that they can wash laundry and provide breakfast, which their Airbnb marketing materials say they provide to their customers. That space is to serve the short-term rental. That's not for creative project space or for a typical home office, which would be controlled as a home occupation under the IDO. In addition,
it shows a dishwasher in the construction drawings.
a dishwasher in the construction drawings.
Okay.
It also has two other separate spaces that are labeled offices, but those spaces have 3/4 baths with showers, and those spaces have separate entrances. They're connected by what you often see in a hotel, which is a connecting door between suites, so that people can pass from one room to another. And to us, that looks like not an office. It looks like a short-term rental accommodation. That's intended to be a sleeping and living spaces for their Airbnb customers. So the plans that were submitted prior to the ZHE hearing and were approved just 2 days after the decision are totally different, in our view, from what their intended purpose to be, which is their home office or their creative project use.
I see your argument. I wish I had those construction drawings here today to look at those. I haven't seen those. So I will look at those and I will include those in the record. So thank you for being extra careful describing the detail. Is there any other detail in those construction drawings that I should be made aware of?
Well, this is a somewhat of a down in the weeds kind of observation, but it appears that Zephyr Renner is going to be the contractor for the construction of this building, and I know that's allowed under the city under certain circumstances, but we would just question it if allowed to proceed as planned. He would be creating spaces to be occupied by the general public, and is a homeowner constructed building really appropriate for spaces that are occupied by the public, and that would need to be ensured that the spaces is constructed appropriately and has all the right utility services and meets all the public health requirements. That I can understand a homeowner constructing an accessory building for storage. That's often done and that doesn't harm anybody. But if you're going to rent the space out to the public, it seems to me that a higher standard is appropriate. Let me just jump, and I apologize. It's difficult to do this when you haven't seen our written argument, but let me just jump to my kind of final observations and conclusions. In terms of final observations, aside from the error that we believe was created by the planning department in allowing accessory dwelling to be used as a home occupation, this case highlights the broader concern regarding the lack of regulatory control over short-term rentals. As we have mentioned, they are not controlled under the IDO, and the STR ordinance provides by the city provides minimal but important guidance limited really to registration and payment of taxes. Notwithstanding our arguments in this case, the comprehensive land use guidance is lacking, particularly concerning the likely explosion of requests for accessory buildings for STR use, which many communities have specifically prohibited. So in conclusion,
let me ask you a couple of questions. I'll give you all the time you need. The STR ordinance, can you give me the citation for that? I haven't seen that.
I can. Let me find it here. Bear with me a minute.
Sure. It'll make it easier for me to find it. And STR, for purposes of clarity, means short-term rental?
Short-term rental. Yes, sir. Apologize, this is taking some time here.
If you don't have it immediately, that's fine. I can look it up fairly simply without the citation.
This is Kevin Murphy. I have it in front of me if that helps.
Mr. Murphy, thank you. What is the citation?
0-2020-038. That's enactment number. The council bill number is 0-20-30.
Right, okay. But you don't have the citation in the ordinances for it. I can find the enactment. No problem. Thank you. Thank you, Mr. Murphy. I'm sorry, Mr. Renner. Thank you. Or is that Kevin Murphy?
That was Kevin Murphy, the appellant.
Okay. My screen doesn't pop up like that. Okay, good. Thank you, Mr. Murphy. Now, Mr. Murphy, I have a few questions for you regarding your argument. Now, you opened your argument by making the allegation that the home occupations are not allowed as accessory dwellings or accessory buildings. Where is that in the ordinance? I didn't see that in the IDO.
Well, the home occupations are allowed under the IDO. They can be within the primary dwelling, or they can be in an accessory building, a separate accessory building. And our argument is that what was approved by the ZHE was an accessory dwelling, and that the accessory dwellings have a unique relationship to the primary dwelling, and that relationship is basically residential. So to allow a home occupation in an accessory dwelling, which really is the residential connection to the primary dwelling, is a mistake. We're not saying that it can't be in an accessory building, because that is allowed under the IDO, but calling it an accessory dwelling and then allowing a home occupation doesn't comport with the structure of the IDO.
Okay.
And by the way, if a business uses or business activities are in this case in a kind of R1 zone, and they're allowed in an accessory building, those uses must comport with the special use criteria or standards in the IDO, which are very limiting. Don't allow outside activity, limited to 2 customers at any one time, can't have employees except family members. So there's a whole list of criteria that would have to be satisfied and adhere to if one were to build an accessory building or a home occupation.
I see that there are subtle differences between an accessory dwelling and an accessory building. I'll compare those differences. I understand your argument a little better now. Okay, good. Boy, I sure wish I had those documents that are missing from the record. Can you tell me when you submitted those documents?
Submitted it on the 15th.
On March 15th, and you sent them via email?
Yeah, and it was done, and it included the entire list of individuals that were on Crystal Ortega's communications to the participants.
Now, that's strange because those go to me automatically. I mean, those don't get shuffled to me by another person. If you included me in that email, I would have gotten it. And I did not get your email. And I'm guessing that Ms. Ortega did not get your email. So you may want to check to make sure you sent it. But if you didn't, let's get it in the record. I will include those into the record. Are you done, Mr. Murphy? And you do have some rebuttal time.
This is
Yeah, the only thing that I would just also mention, because this is of concern to the appellants as well, is that there is a number of business activities that are occurring on the property currently that probably don't, it's beyond probably, I think that are obviously not conforming to the home occupation the home occupation standards within the IDO. And one of the principal ones is religious services that are being conducted outdoors weekly, that are open to the public, advertised by signs on the streets, so forth. That is not within the limits or satisfy the requirements of a home occupation. That is well beyond those requirements and should not occur.
Now that's an enforcement issue, and I think the mirror is also an enforcement issue. And I think the ZHE got it right by not including that into his findings, because they are separate issues. And so if there are issues that you believe are in violation of the IDO, aside from the application issues, those are enforcement issues for the zoning department. Okay.
We understand that. We raised them in this proceeding because if the owner applicant's desire is to relocate, which, as they said, relocate our business activities to the accessory dwelling, then I think that we believe the planning department may have erred in not investigating what those current business activities are and whether they meet the requirements of a home occupation. Because if they violate home occupation standards within the primary building, or primary dwelling, then it's likely that they would violate the IDO if moved to an accessory dwelling as well.
But you have no evidence to submit that would demonstrate that the renters are using the proposed dwelling, accessory dwelling, or building as a religious use, correct? You believe it's being used to expand the B&B.
You're absolutely correct.
Okay, thank you. Great. Now you are subject to cross-examination. Mr. and Ms. Renner, do you have questions for Mr. Murphy? Only questions. I will allow you the time to make arguments, but this is the time for you to just ask questions of Mr. Murphy.
No, we have no questions.
Okay, thank you so much. Then you have time as well to make an argument and to address those issues. Now, you probably have seen your drawings that were submitted into the record. I haven't seen them, so you'll have to be a little bit more detailed in addressing those with me, okay?
Of course, and thank you, Mr. Chavez. This is actually will be very short because we have in fact amended our plans to bring the project completely into compliance with permissive use through the IDO. So we actually do not need a conditional use any longer, and our permit has already been approved by the city departments.
Well, now I'm not concerned with that because this is an appeal of a decision from the ZHE,
right? And
I'm dealing with hold on. If I find that there is substantial evidence to support Mr. Murphy's argument, I can recommend to the city council that the ZHE's decision be reversed, or I can just remand it directly back to the ZHE to address these issues, to find out more and to flesh out the issues, the factual issues, so that he can determine what the use is for. Okay, so it's relevant now, and so please give me the detail that I need.
We understand, but we actually, we amended our plans. We've connected the building to the house is no longer an accessory building. So we actually have no need for it to be, zoning doesn't say we need a conditional use at all for what we're intending to build. And they told us that when we talked to the city, that we would come to this hearing and tell you we don't need this. So it doesn't really matter to us how you find in conditional use.
It matters to me because, and it matters to the city council. I can remand it back to the ZHE to accept a withdrawal of your application.
Okay, that would be fine. We would withdraw our application for conditional use. I'm sorry,
We don't need it.
we don't need it.
Okay. Okay. I will remand it back to the ZHE. I can reverse the ZHE, but I don't want to do that because it goes to the city council, and I don't think the city council wants to be bothered. Well, let me put it this way. It's not that they don't want to be bothered by it. It's that they don't want to deal with it until all the evidence is in the record. And that's what my job is, to make sure that all the evidence is in the record. Let me ask Mr. Murphy, do you have a response to what Mr. and Ms. Renner just testified to, that they're going to withdraw their application? I suggested that I remand it back to the ZHE, allowing them to withdraw their application.
Well, without seeing their amended plans, it's which would be an indication of their intended use of the addition. It would be hard for me to judge if they are merely taking the plans that have been previously approved and moving that structure and connecting it to the primary dwelling. I would suggest that the planning department do a more thorough, require more thorough plans to be developed, and an additional review of those spaces relative to the allowable uses within the zone district.
Okay. I don't have authority over the planning department. Other people do. You may want to contact the planning director yourself and talk to him about what is being proposed in lieu of what was approved. In my remand, I can assume that my remand will be with a few instructions to determine whether or not the application should be denied or allow the withdrawal. I can do that, instructing the ZHE to look at those issues. It will be in the ZHE's jurisdiction to either accept the withdrawal or not accept the withdrawal. I can't envision a reason why he would not accept the withdrawal unless there was some bad faith intent. I don't see that here, but that would be up to the ZHE to determine factually. Okay.
Very good. I would just, and you said you've indicated that once you receive the written argument, you will review it. That may cause you to not change direction, but maybe emphasize certain things with the ZHE.
I think you're correct. Yes, because it looks like that information is very important to the analysis. So please still submit the information as quickly as you can, and send a copy to Mr. and Ms. Renner. Don't make an argument with your email, and we will go from there. Is there anything that you would like to conclude with, Mr. Murphy?
No, I appreciate very much your attention.
Okay. Thank you, Mr. and Ms. Renner. Is there anything else you would like to add? Would you care to address the issue that Mr. Murphy, and it's an important issue to me, and that is whether or not you included in your application a justification for your application that is not in line with the facts?
Absolutely not. We were completely truthful.
Okay.
And we talked about the utility space at the ZHE original about why we needed that utility space. I do a lot of laundry. I sew. I need washer dryers. It's just the thing.
I understand.
So that people can claim whatever they want to. It's hard. But we changed. We did what we need to do on our end, and we're happy.
Okay. Thank you, folks. I appreciate your time, everybody. Let's go off the record. Bye-bye.
Bye.